The Supreme Court takes a new Second Amendment case, plus a rabbi from the New York State Jewish Gun Club on a federal judge upholding the synagogue carry ban. That and more on this episode of the Weekly Reload Podcast.
No, the devil's got no hold on me.
All right, ladies and gentlemen, welcome to another episode of the Weekly Reload Podcast. I'm your host, Stephen Gutowski. I'm also the founder of thereload.com, where you can head over and sign up for our free newsletter if you want to keep up to date with what's going on with guns in America. This week, we have an update on the fight over the church and synagogue gun ban in New York State. There's a new ruling that has come out in favor of that ban from a federal judge in New York. So this week, we are having somebody who's directly affected by this ruling on with us. Welcome to the show, Hershel Goldstein. How are you doing today, sir?
Excellent. Thank you for having me.
And you are you're a rabbi, and you live in Rockland, New York, which is about an hour north of New York City, in the Southern District for federal cases, correct, which is where this ruling comes out of. And you're also a member of the New York State Jewish Gun Club, right?
Correct.
Okay, and so you're directly affected by what happened here.
Yes, I am.
Can I get your reaction? What, just detail for us how this affects you. You know, this judge upheld this law, but obviously the whole situation is pretty fluid and complicated. How are you today affected on the ground by this? Okay,
so just a disclaimer, I'm not a lawyer. This is not legal advice, right?
Sure.
This is extremely frustrating, this ruling. New York State actually voided this law and changed it before the judge got around to issuing this ruling. So even New York State is not defending this as lawful, but the federal judge still comes down and says, "Oh yeah, I think it's fine." So I think the federal judges down here and their refusal to uphold the Constitution, refusal to defend the Constitution, is just horrible. It's really bad. And I want to go ahead I want to talk to you a little bit about what this law did to us and how these emergency laws keep coming down. It's like a tidal wave of law after law after law, and you go to court and you wait around for a decision. You know, you get 3 more laws before the first one was adjudicated. Right.
And well, for those who don't know, we did a podcast earlier with a colleague of yours who's the founder of the New York State Jewish Gun Club, Tzvi Waldman. But anybody who doesn't understand what's going on here, can you just describe how this law, as it was originally enacted, worked?
Okay, so we're going to go before Bruin, or we're going to go where we're going here?
After Bruin. So this
is for 100 years, we had to fight in New York to even get a carry permit. Right. You apply, you have no criminal background, you have no mental health background, you apply for a permit, and you didn't give a good enough reason. Well, they're targeting synagogues, they're killing Jews. Not a good enough reason to get a gun, to get to hold a little Glock on your person when concealed when you go to synagogue. Okay, so Bruin comes down and says you got to issue these to everybody who applies for them. Immediately, in the middle of the night, the legislature in Albany, supermajority Democrat, come out and say, well, we have to do the Concealed Carry Improvement Act. They always have these, Orwellian terms, and they say, well, you can get a permit, but you can't carry in a sensitive area. And really, the term sensitive area is a misnomer, because Bruin is talking about a sensitive government area, in the legislative body, in the polling booth, in the court. And New York State said, well, a sensitive area includes any public property. It includes a whole bunch of places, but one of the places it includes is any place of worship or religious observation. So if I wear a kippah, is that a place of religious observation? Can I never exercise my Second Amendment rights to carry? A place of worship. So does that mean if I get together at work with 10 guys, middle of the day to pray? We pray 3 times a day, Orthodox Jews. So, we pray in the morning in a synagogue, we pray at night in a synagogue. In the middle of the day, we're at work, we get together, 10 minutes, we throw it together, we call it mincha, we pray. Is that a place of worship where we gather to pray every day? It's unclear. And I'm a felon if I walk into that prayer group carrying, right? So am I going to exercise my Second Amendment right to carry, or am I going to exercise my First Amendment right to pray.
Right. Yeah,
So-
it's unclear to some of that stuff, but it's very clear that they definitely mean synagogues, right?
Well, they definitely mean synagogues. And place of religious observation, I mean, the Attorney General tried to argue, well, maybe it means another place of worship, gathering, places, meaning they try to reference some sort of groups that don't have establishments, places that they go out and pray in the field.
So
but yeah, none of this is in the law.
Broadly. Yeah, they take it very broadly, is what you're saying.
Yeah, but places of worship are places of worship, and that's one of the problems. Well, one of the problems is I can't exercise my Second Amendment right and my First Amendment right. The federal government is not allowed to discriminate on the basis of religion. So we had when COVID came out, we had the Archdiocese versus Cuomo. And Cuomo said, well, you can't have big stores, you can't have small stores, you have to have, they had the red zones, the yellow zones, the green zones, but no synagogues. You can't pray in a synagogue. And the courts came out and said, well, you can have a tiny synagogue, you can have a massive synagogue, you can have a tiny church, you can have a massive church. So church is not a proxy for a large gathering. It can't be. And the New York argued that, well, when we say church, we mean a large gathering. And the court said, no, you're targeting religion. That's what you're doing. And that's what we argued here as well. When you say you can't carry in a synagogue, it doesn't say if it's a 10-person synagogue. It doesn't say if it's a massive synagogue. It doesn't say if it's in New York City. It doesn't say it's out in the bungalow. It's just a synagogue. And the federal judge here made the same error that the federal judge made in Archdiocese versus Cuomo at the trial level, saying, well, you regulate a lot of places, you regulate subways, you regulate airports, and you regulate synagogues. And the Supreme Court didn't take that in Archdiocese v. Cuomo, and I think this is going to be overturned on appeal as well. You say church, place of worship. That's regulating religion. That's discrimination on the basis of religion. That's not lawful.
And so that's how you feel about this restriction, right? This sensitive place restriction, that it's not just infringing on your Second Amendment right to carry a gun, but also on your First Amendment right to worship.
Correct. And we never would have brought this case in the Southern District if we wanted a good Second Amendment ruling. The Southern District is a horrible Second Amendment place. And we see in the Northern District, we're getting all these good Second Amendment rulings about, where's what the historical, what the historical history is, tradition, for regulating synagogues or regulating sensitive places. But for the First Amendment, I mean, you shouldn't be discriminating on the basis of religion. It's a pretty basic concept. And we're very surprised that this judge would come down and say, yeah, we're regulating places of worship, but we're also regulating a lot of other stuff, so it doesn't matter. That's just gibberish.
And this is the second case that you guys at the New York State Jewish Gun Club have been involved with. There was another case previously with the same judge, right?
There's several other cases. I'm not sure all of them. I think this is the first. Is this the first federal lawsuit that we've backed? So a bunch of state court lawsuits as well, and freedom of information and other stuff.
But
I'm not a
right. I know you're not a lawyer, but you have you consulted on this case, or you helped with organizing it, right? You're not a plaintiff. There's a plaintiff named Stephen Goldstein.
I'm not Stephen Goldstein.
You're not
I'm Hershel Goldstein.
Right.
Yeah. When this law came out in the middle of the night, we went scrambling. We had to fundraise. We had to identify what type of plaintiffs, what type of case we should bring. One of the things the judge says is, "Oh, you waited 3 months to file this lawsuit." This law passed. There was no, notice and comment period. This law passed instantly. We had to fundraise. I mean, all these lawsuits are expensive. And we had to identify correct plaintiffs. A lot of people we wanted someone who had a full carry permit on the one hand, so they could legally carry before Bruin. But we also didn't want anyone who had a security guard license, because there's an exception in the law if you're also a security guard. So a lot of people who are going through the effort to get a license to carry in New York add a security guard license as well, just to have that additional qualification. So we had to find a plaintiff who had one but didn't have the other. And then we wanted someone, obviously, who was willing to file the lawsuit and be a plaintiff, and we found 2 plaintiffs. All this takes time. and drafting, what issue should we bring, where should we file? All this stuff takes time. So it was a lot of work. A day before the judge calls it a hearing. We never had a hearing. A hearing is where someone goes into court, raises their hand, and testifies. I'm the plaintiff. This is how I'm affected. Someone comes in from New York and says, this is the legislative process. Here's what we considered. Here's the security. We had oral argument. Again, the judge is playing really fast and loose. That's not a hearing. He took oral argument from the lawyers. He did not allow anyone to testify.
Yeah, and I know that you have more complaints about how the judge handled this case.
Right,
I do want to get to those, but
but I'm also telling you my involvement is the night before the oral argument at 9:00 at night. We get an email from the judge with 17 questions that he wants answered, like what's the history of this, or what's the history of that. One of our plaintiffs was on a plane, to Israel at the time. One of our plaintiffs was in Australia at the time and was asleep. We had to find someone to wake them up so we could get answers to these questions. How many times did you go to synagogue? How many times did you carry? When we had a hearing, when we had the oral argument scheduled for 9:00 the next morning, this is less than 12 hours overnight. And so we're scrambling, we're drafting it. And again, you don't draft something once. You got to read it and reread it and proofread it. So, all this had to happen behind the scenes in order to get the case to where it was. But anyways, back to the decision.
And I know that's not the only issues you have with the process here. And we'll get to some of that in a little bit, especially when we talk about the larger implications of this ruling and the larger atmosphere it's happening in the legal atmosphere. But before we do that, let's talk a little bit about the specific claims in the case and the judge's ruling itself. So, you guys were using the Bruin standard, the new standard created in New York State Rifle and Pistol Association v. Bruin in 2022, where now for a gun law to be constitutional, it has to the defendants, the state has to demonstrate that it's consistent with the historical tradition. And you guys said that these regulations on carrying, this effective ban on carrying a gun in a synagogue or church, if you have a license you're a licensed carrier, you're somebody who's passed the background check, you've done the training required, you still can't carry there. You're saying that's not constitutional, right? That was the basis, that there's no historical analog to anything like that, right?
Correct. So that was the Second Amendment claim. The Second Amendment claim is the state government has to show how at the time of the founding, how the constitutional right was recognized. The right to carry. So if there was a restriction at the time of the founding, then that would be lawful now. So at the time of the founding, they had laws where you could not carry into a legislative session. They had laws that you couldn't carry into a courthouse. They had laws that you couldn't carry into a polling place. These were very, by the way, there were no polling places at the time of the founding. This was a brand new invention, right? Until the founding, the polling place was the battlefield. That's where we had our political differences. So they would assume that a polling place would be a place of, bloodshed, of strife, of people fighting. And that hasn't been our experience, thankfully, in this democracy. I mean, we have a peaceful transition of power. But at the time of the founding, who was regulating guns in a synagogue? They probably didn't even know where the synagogues were at the time of the founding, or the churches or whatever. So this was not historically a government-regulated place. I've never seen a cop in my synagogue. They're not providing security in synagogues. My child's daycare. You think you got a cop outside, my private daycare where my child's going? They're saying, oh, it's a sensitive government area. These are not historically where the government has provided security, has locked the place down, has said we're going to check everyone for guns, we're going to secure the area, we're not going to allow protests to get violent and spill into the legislature. That's the type of thing the court was talking about in Bruin, where there was an historical government focus on protecting these areas that never existed in a place of worship.
Right. Now the judge obviously disagreed with this, and and one of the key things to his ruling
he didn't really disagree with it because he didn't find any case at the time of the founding. What he said was that at the time of Reconstruction.
Right.
So
this is what I mean.
Yeah.
Like he did.
Yes.
Yeah. He didn't find he didn't use examples of laws from the founding era. What he
Correct.
did instead was use examples of
Correct.
various gun bans, really that were Reconstruction era. So he's
Right.
This
and
is
why is that relevant? Tell us, Steve.
Well, his argument is, and this has become an increasingly common argument that you'll see in court from state defendants, that the relevant period should be extended to when the 14th Amendment was ratified, because the 14th Amendment is how the Second Amendment was incorporated to the states, how Second Amendment protections were incorporated to the states. And so that seems to be where he's come down on this, that there were some gun bans or carry bans. They're not all really similar to each other, the ones he cites, but they all come from the South in Reconstruction era after the 14th Amendment was ratified. And that's why there's a basis to do this. And I wonder, do you think that line of reasoning is going to be a hurdle for you guys as you approach the Second Circuit, which is obviously a more left-leaning circuit traditionally on gun issues? This argument might be something that they are persuaded by. Are you worried about that at all?
The Second Circuit is not a friendly forum, definitely. And we may see a circuit split. And again, the only way to get a case up to the Supreme Court usually is to get a circuit split. So if you get a favorable ruling out of Texas and you get an unfavorable ruling out of the Second Circuit, that's how you can get up to the Supreme Court. So it's kind of the process. One of the things the judge said is, blacks didn't have the right to carry at the time of the founding. So therefore, maybe no one should have the right to carry now, which is such a bizarre racist argument. Blacks didn't have the right, against search and seizure. Are we going to take that right away now from everybody because they didn't have it at the time of the founding? The judge was very highly motivated. If you read the transcript, I was actually there at the oral argument, talking about race, talking about religion, what specific religions are more Second Amendment focused. This is it's legal gibberish. We treat everyone the same. We treat blacks, whites, Jews, Hispanics, Asians. We treat everyone the same in this country. Everyone has the same rights. And if we didn't do it at one point, then we fix that and we give the same rights to everyone. We don't say, well, because the blacks didn't have the rights, at the time of the founding, so I'm not going to apply those rights now. It's gibberish. And he didn't even put that in the decision because, he probably wrote it and then, hit backspace because it's ridiculous.
So you're saying he said that during the oral arguments that you
Yes. Yeah.
Interesting. Yeah, because there was a section in the ruling, because I didn't see that argument in there, like you said.
Correct.
But he did talk about, because the case that you guys brought cited founding era laws that required people to carry guns in church. Correct. Because those did exist. But he claimed that they were racially motivated laws, that they were motivated by the fear of either slave insurrection or Native American attacks, and therefore shouldn't be considered, which I thought was interesting because, frankly, a lot of those laws that he's citing, some of them are a bit more explicit in what he's talking about, but many of them aren't. And at the same time, New York has used explicitly racist gun bans as the basis for many of their legal arguments in defending its post-Bruin restrictions. And I just thought it was odd to see that, that it's the potential that some of these carry, requirements for people to be armed at church had motivations that were unsavory. And I think that is even kind of questionable, makes them ineligible for consideration in this case. But I haven't seen any of the judges in the Second Circuit say that the explicitly racist ban, like literally just don't sell guns to Native Americans or African Americans, aren't allowed in for the same reasons.
Right. If you subscribe to critical race theory, then everything is race. 1 + 1 = racism. Finished. and that's your starting point, and that's your conclusion, and you bump into some other irrelevant facts along the way, like constitutional rights and people actually shooting up synagogues and whatnot.
But anyway, that's kind of an aside. I just thought it was an interesting bit in there where he's rejecting these actual founding era laws because he believed that they were racially motivated. But we've seen it's just sort of a quirk of how these cases have come out, I guess.
By the way, if there's going to be an Indian, if there's going to be an Indian attack on your synagogue and you don't want to be attacked, is that racism?
Right. That is, I think, a little bit of a weird.
You have to stretch to find
extension.
racism everywhere. Yeah.
Yeah. So, where are we at now? Let's talk about this. So, this judge has upheld this provision, this total ban on carry other than people who have the security guard clearances. Even though the state, as you mentioned earlier, has given up on this, basically. Correct. Right? What is the status of the law at this moment?
So the law that the state enacted that we challenged was, it's a sensitive area you may never carry, no matter what permission you have, no matter how many permits you have, unless you're a licensed security guard, insured and everything, or a police officer, you cannot carry in a place of worship or place of religious observation. That was the law that was passed. In the budget from 2023, so that passed, I don't know, maybe a month ago, not that long ago, they removed the second half, which is place of religious observation. So that's out entirely. And they modified the first part, place of worship, to conform with the district court decision out of the Northern District. I forget which, I think it was Antioch versus Hochul, which said there must be an exception for people designated to security. So currently, as the law reads now, a place of worship is a sensitive area unless you're designated as security. So if you come in off the street to a synagogue, you can't carry. If the rabbi or pastor or priest gives you permission, you can't carry. If the rabbi says you're in charge, you're part of the security team, now you can carry.
Okay.
That's how the law reads now. Now, the backstory to that, which I don't think the federal judge in the Northern District picked up on, is in the New York securities law. If you are designated as a security guard or you're designated to perform security, you have to be licensed and insured. Otherwise, it's a misdemeanor.
Oh, really?
Yes. So you have to be a security guard anyway.
That's how you read this new law, is that it's kind of there's a new exception, but it's kind of the same thing.
So, no, well, the law says what it says, and the misdemeanor is probably on the organization, not on the person. So okay. instead of being a felon when you carry into synagogue, if you're designated as security, you're a felon if you're just given permission, or the state can go after the synagogue for not having the proper insurance and not having all the people licensed as security guards. So
because they have to officially designate you as part of the security team, and if they do that, they have to, even voluntary, even if you're doing it for free, New York requires you to be licensed. Okay. So we're going to have to do a deep dive into the securities law and the regulations and all that wonderful stuff. Mm-hmm. So I don't think the federal judge understood New York state law that well and all the intricacies and how, there's always another law. I mean, there's so many laws you have to dig through. You can't just wake up one morning and say, I'm going to be a law-abiding citizen. I mean, you have to study this stuff. And then maybe, you could take a step out onto the street. Yeah, certainly. So I guess in the end, though, that means that there's been less practical change for your average, worshiper than what it might appear on the surface. Well, I think not. So number one, place of religious observation is out. So if I walk around wearing a yarmulke just down the street carrying, I'm not a felon anymore. So that's out. And I think that's a total vindication. And the fact that the judge doesn't even discuss that, he mentions in a footnote, well, they took that out, so I'm not going to address it. Well, wait a second. You just made all religious observation a felony if you're carrying. And we brought a lawsuit, and the state rescinded it. So tell us we won, right? Tell us that was illegal. Tell us that the state shouldn't do that again when they make the next emergency legislation or the next emergency act.
So number
is
one, that was a big win.
Yeah. But otherwise.
So for synagogues, I was designated to our synagogue security team well before Bruin. So I'm no longer a felon if I carry in my synagogue.
That's good.
Practically. Whether the synagogue's going to get in trouble if they look into whether we're properly insured for, security guards, at least I'm not a personal felon when I carry in my personal synagogue. Now, if I go to the synagogue across the street, well, legally there's still some risk. Yes, right. Legally there's still some risk, but the risk is much lower. And again, if a cop if I'm involved in a shooting or I'm pulled over and a cop finds a firearm in a synagogue, they have to prove that I wasn't designated to the security team in order to prosecute me as a felon for carrying in a sensitive place. And I think practically that's a big difference.
Right. Yeah. Yeah. So that's fair. But at the same time, it's not as though any worshiper can carry even if they have a permit. So there's still quite a lot there that you guys would like to see changed at the end of the day. 100%.
Yeah.
And so that's perhaps one of the reasons why, this case still matters, right, going forward, especially because, as you mentioned, they could just change the law again at any time if they wanted to, if you don't get a final ruling from, these judges that says this is unconstitutional.
Correct. And they keep passing new emergency rulings. The COVID ruling saying you couldn't carry in a synagogue, you couldn't go to a synagogue, was passed as an emergency ruling. The Supreme Court said, hey, you're discriminating on the basis of religion. Here they passed an emergency ruling. You can't carry a gun in a synagogue as an emergency ruling. New York is very litigious, and they're very happy to change the laws. They have a supermajority. It doesn't take them any time at all. What's the next law that's going to come down the line? If we don't stop them at every turn and we just let them run roughshod, then they're going to run roughshod. Freedom isn't free. We have to protect it. Thank God, it's pretty easy for us to protect freedom. We just go into a court. It's air conditioned. It's some money, but this is relatively easy for us to protect freedom compared to, people fighting in Soviet Russia or North Korea or China to get their freedoms.
Yes,
we have to protect what we have. Yeah,
still have the ability to redress our grievances here in the United States, thankfully, even if it doesn't always go our way and it doesn't always go as quickly as we would like to see. Right. Correct. But that is a very important and good point.
But if we let it go, they're going to go. They'll take all the power they can get if we don't push back. So we got to push back.
So let's talk about the landscape now, the legal landscape after this, because there were three other rulings in New York,
Northern and I think Western,
or so.
Correct.
Two. But I guess there were three rulings out of two. There different districts. There was
another one. I think there were four. There's four at the Second Circuit right now.
Okay, but in this specific restriction has been litigated a lot, is I guess the point. And in every other case outside of the Southern District, it's lost, right? This restriction.
Correct. One of them was more addressing the FFL and the sales and stuff. So that was one of the four cases.
Yeah, there were other cases about the overall law, but the
other three all found that this was unconstitutional.
Right. This has been one of the most litigated points of this new law, and it's lost except for in this case.
Right. Which just goes to show you, New York, you could have done this in a smart way. They didn't want to. They wanted to openly come and say, we can violate any constitutional law we want. We will outlast you. It took you 100 years to knock down the old one. We'll just keep passing laws. You courts are too slow. You knock down one, we'll pass another. And, eventually we'll win. In the meantime, we'll win. They have no respect for the courts or the constitutional process. And, so I think that's their attitude. It was during the governor debate between Hochul and Lee Zeldin. Mm-hmm. And Hochul said, we got legal guns. She didn't say illegal guns. She said, we got legal guns off the street in New York. And Lee Zeldin said, well, that's unconstitutional. They'll get struck down in the courts. And she said, well, we've got good lawyers and we'll just play it out in the courts and who cares? But
you expect to win in the end here is how you feel.
Absolutely.
Now,
Absolutely.
Right now,
and if not this case, it'll be the next case because we're not backing down from this. New York cannot do this. They cannot what did the judge write? He said, you can choose. You can either go to synagogue or you can carry, you can choose which constitutional right you want. One of the interesting legal arguments here is, what is a sensitive area? Because the Supreme Court kind of threw out there, 4 examples: courts, legislative bodies, polling, and schools. So what does that grouping give you, right? So the New York AG argued, any place where you exercise a constitutional right, that's where we can take away your Second Amendment. That was their argument. If you're exercising a constitutional right, and worship is a constitutional right, that's where we can take away your Second Amendment. What about the home? Well, the home's an exception. So New York's position is, if you are exercising any constitutional right, you don't want to be searched and seized, you want to have freedom of expression, you want the right to a lawyer, you want the right to remain silent, you have to give up your right to the Second Amendment. That's their position. It's crazy.
But so, I mean, I guess they argue things like, if you're, that having guns around can be intimidating to people while they're worshiping or while they're
We only
protesting
have
and
concealed
so
carry. If you print if anyone can claim that they saw a firearm and they report that to the police, you're getting arrested. All right. So we're talking about concealed carry here. There's no open carry in New York. Nothing. We're talking about a little pistol that you hide in your pants. All right. You pull out anything else in your pants, you also get arrested. There's no reason that to restrict. There's absolutely no reason. By the way, I want to give you some examples of even courts, even polling places. You don't always see security there. Often in small claims court, not in the county courts, the little small claims court, the little landlord-tenant courts. There's no security there. There's no one manning the place. So what? The government's providing protection? The government's taking away all your rights to protect yourself and saying, "Oh, what happens, happens." How is that good policy? How is that responsible? It's not.
And so, just to wrap things up here, now you're headed up to the Second Circuit. You guys are planning to appeal this case. There's also an issue with timing, right? Is this going to get lumped in with the other cases we discussed earlier, where they're already at the Second Circuit? The Second Circuit's already going through, the procedure on considering those cases. Is this one going to get left behind? What do you think is going to happen with it?
So I don't know the procedure so well, but I can't imagine that this case is going to get lumped in with those. Those cases have expedited briefing schedules.
Right.
So usually there's a regular briefing schedule. You mail in your brief, you mail in your record, you get 30 days, you get an extension, you get a second extension. All those cases were already briefed and argued months ago. So there's no way that this case is going to get briefed and argued and decided along with those cases. It's impossible. If anything, hopefully that decision will come out and we'll ask this judge to reconsider. But again, we only have 30 days to appeal, and the appellate record is what we have until now. So we have to appeal this case as it is.
Do you think it'll get put on hold while those other ones are being considered then?
I think we're going to get, I think we're going to get that decision any day now. And by the time the briefs are filed, we're going to be citing those circuit cases.
Okay.
In our favor.
Interesting.
Yeah.
Okay.
Which should make for an easy appeal, because there's no way those cases are going to lose in the Second Circuit either.
So you're confident that the other cases against this place of worship, church, synagogue restriction, that they're going to win?
100%. 100%. Okay. I have no doubt in my mind.
And if they don't, are you prepared to go all the way to the Supreme Court?
Absolutely. And we'll probably join up with those at the Supreme Court if it goes that way. It'll be, because if we lose, it's a quick decision. Just cite that case, pass this along,
Yeah, absolutely. All right. Well, we really appreciate you coming on and sharing your involvement in the case and your experience up there in New York with fighting against this new restriction. We'll have to have you or Tzvi Waldman on again in the future just to update us as this all progresses, because we like to try and talk to people who are directly affected and involved in these situations whenever we can, because I think that's the sensible thing to do. And so I really appreciate you joining us and And where can people find out more about New York State Jewish Gun Club if they'd like to?
I think you Google New York State Jewish Gun Club, you'll find us. We're online.
All right, wonderful. We're going to head on over to our news update now. Thank you so much for being with us.
Thanks for having me.
All right, ladies and gentlemen, it's time for the weekly news update. I'm contributing writer Jake Fogelman, joined, of course, by Stephen Gutowski. How you doing, Steve?
I'm doing all right. How are you?
I'm doing pretty well, especially because we have a sort of a special news update for the listeners this week because we got some breaking news the day that we record the podcast, some huge Supreme Court news. If you want to tell us what the Supreme Court just decided to do. Yes,
this is our second attempt at the news update because we had to refilm because this is bigger news than anything else that's gone on this week. And that is the Supreme Court has accepted a new gun case. About 1 year after they handed down their decision in New York State Rifle and Pistol Association v. Bruin, which set up a new test for how to determine whether a gun law is constitutional or not. Now they're taking up a case on this question. And it's a case called United States v. Rahimi. Comes out of the Fifth Circuit. We've written a bit about this in the past, or actually quite a lot about this case in the past. A number of analysis pieces from members over on the Reload if you want to go and check those out. Today, you get a membership, you can do that, but it's a pretty significant move because this is only the seventh Second Amendment case that the court has ever taken in its history, right? This major ones, at least. And it's the third of three of those seven have come in the last 3 years. One was mooted. There was a New York case before New York State Rifle and Pistol Association that got mooted. Then there was Bruin, and now there's Rahimi. So it's going to be very significant because there's just not a lot of case law. There's not a lot of jurisprudence from the Supreme Court on the Second Amendment, what it means, what its limits are. And so here we're going to find out some more answers to those questions.
Yeah, it's definitely huge because not only because of what it says for Second Amendment jurisprudence, which is obviously critically important, but I think this case in particular makes it that much more significant because of just the sheer amount of headlines that this ruling initially generated when it was handed down. As you said, this deals with a not particularly good person who was convicted of possessing a firearm while being under a domestic violence restraining order, but he was certainly engaged in plenty of other conduct that we wouldn't want someone to be engaging in typically in society. And so the fact that this ruling came down just put so much attention and so many eyes on the Supreme Court, what they might do, what will they let this stand? So that just adds, I think, to sort of the excitement or the attention around this case.
Yeah, it certainly does. Rahimi is the least sympathetic plaintiff you could probably think of.
Yeah.
This is not a case, as we talked about in the past, that was backed by the gun rights groups. The gun rights movement was not trying to get this case to the Supreme Court, right? They're much more focused on, assault weapons bans or magazine limits or concealed carry restrictions. This is actually a public defender who was involved in this case. And it comes out of the pot of criminal cases that involve the Second Amendment or involve gun rights. And those are much more of a wild card, right? These sorts of cases are wild cards. They're not really as predictable as a lot of the other cases where you're used to seeing that talk about the Second Amendment. And so Rahimi himself, he's got a long rap sheet, or at least a long list of accusations and allegations against him, charges against him. So he was accused of committing an act of violence against his mother, the mother of his child, which is what led to the domestic violence restraining order. But he doesn't, to that point, he doesn't have any felony convictions, right? And he still doesn't to this moment, as far as I'm aware. However, the police found that he had guns in his house while under this restraining order, which under federal law makes you a prohibited person. You can't own guns, you can't buy guns, you can't possess them when you're the subject of a domestic violence restraining order, whether it's a federal one or state one. In this case, it's a state order. But the reason the cops found that he had guns was because he went on this like crazy crime spree, basically, or he's accused of going on a crazy crime spree, I should say, that involved multiple shootings. He shot at somebody that he had sold Percocet to. He shot at somebody during a road rage incident after he cut them off. He shot into the air at a Whataburger because his friend's card was declined. These are the allegations against him. And those are all obviously serious crimes as well that are very likely to result in felony convictions for him, which means he'll probably have his gun rights taken away under those provisions. But the key bit here is that while investigating those other crimes and those other allegations, the police found that he had guns in his house, even though he was subject to this order. And so the Fifth Circuit looked at this case, and it's interesting, right? Because they originally they've looked at this exact law before in the Fifth Circuit, and even very recently ruled that it comports with the Second Amendment. It's not a violation of the Second Amendment to take someone's gun rights away if they're subject to a domestic violence restraining order. But then Bruin happened, and that changed how lower courts are meant to examine gun laws and whether they're constitutional. And now the Fifth Circuit had to find historical analogs for this kind of restriction dating back to the founding era. And essentially what the panel found, this is a 3-judge panel that ruled in favor of Rahimi, was that they didn't exist this kind of restriction for this purpose during the founding era.
Yeah. And it sort of, there's an old adage in sort of legal cases that, hard cases make bad law or bad cases make bad law, or just the facts can get a little tricky. And as you said, it's sort of this perfect storm of certainly an individual that you would think no one would want to be able to possess a gun, but under this Bruin standard, at least as it's been articulated by the Supreme Court thus far, if there's no historical analog that is, relevantly similar to the conduct he's being accused of, it sort of leaves the judges without tools to say that he can constitutionally be permitted to be disarmed, at least permanently or temporarily.
I mean, that's the whole test, right? If the Supreme Court or if the Second Amendment's text covers the conduct, in this case, owning guns,
right,
which it obviously does, then is there a historical tradition that justifies the modern law, right? And the Supreme Court's looking for not just like a one-off law here or there that's in the same, that's somewhat similar to the modern restriction, but like they really want a continuing tradition of it, that this was something that even doesn't have to predate the founding era, but it's stronger case if you can find through, basically English common law history, the same sort of restriction that existed back then, and then carried on through the founding, through the ratification of the Constitution and the Second Amendment, and then on from that point. So if it came later on, if there was nothing like this until the 20th century, the Supreme Court says, well, that doesn't work. That's not in line with what the meaning of the Second Amendment is. And so, the Fifth Circuit went through and tried to look at a number of different laws from the founding period that the federal government had put up as potential analogs. And, it found that there just wasn't anything that was very close to this. I mean, especially because this is a restraining order rather than a conviction that we're talking about. And it's about protecting someone from a specific threat. This is how the Fifth Circuit framed it, at least. It's about protecting someone from an individual from a specific threat from a person, or not a specific threat, but a general threat from a single person. And so it's not about disarming dangerous groups of people, necessarily people who are dangerous to society. That's what they found, that, some of these old restrictions on, some of the racist laws that we've talked about in the past, restrictions on selling guns to Native Americans or blacks or other groups that the legal theory goes, were dangerous to society, and therefore there's sort of this dangerousness standard that some courts have looked at for who can be restricted. It wasn't just those groups. There was also like loyalists were included in there. You could disarm somebody for not taking an oath of loyalty to the United States after the revolution. And so that was another idea of like, well, these people are considered to be dangerous to society as a group. And so the domestic violence restraining order is more about, according to the Fifth Circuit at least, trying to keep someone from owning guns because they are a dangerous threat to a specific individual, namely whoever took out the restraining order. And so they said that's not really the same thing. It's because it's an individual being restricted instead of a group of people. And so they also looked at things like surety laws, which were also they weren't similar for a number of reasons, right? Surety laws had to do with somebody putting up basically a cash amount to insure themselves if they were accused of being dangerous, so that they could carry a firearm with them. And obviously there's some similarity on the dangerousness side of the individual being accused of them being specifically dangerous, but the punishment side is different, right? Somebody in that situation would have to put up, basically a bond or it was called a surety, but it was a bunch of money to then be able to carry their guns. And so it wasn't a total ban on them owning firearms for the duration of the this period of time where they're under a restraining order. So, there were a number of ways where the Fifth Circuit said these laws that have been relied on aren't actually good analogs.
Yeah. And you've seen sort of critics of the Bruin standard overall sort of glom onto that, basically that analysis and say that that's a weakness of the Bruin test. The fact that,
right,
well, this is a modern problem that we clearly as a modern society want to deal with. And if it was just silent, if the historical tradition was silent on this issue, then that's an inherent weakness in the Bruin test, is at least what they would argue. And so that's what I think.
Charles has made that argument, the professor and former head of Duke University's Firearms Law Center.
Right.
That's been something that he's talked a lot about. But there's a lot to it, though. It's not clear exactly how the Supreme Court is going to come down on this, right?
Yeah, right. That's what I think is the interesting part, is just how do the justice, because obviously the justices, they just established this new test. Some would argue it's the Heller test, but they've articulated it explicitly, at least in Bruin, as the standard going forward. So just a year out, you can't imagine that they're going to abandon the Bruin test. So how do they re-articulate the Bruin test in this specific scenario? Do they say it's permissible? Do they find some rationale where it's permissible? Do they get maybe a little looser with the historical analogs that are allowed? Or do they simply say that, the Fifth Circuit got it right and it's just the history is what it is? I think that's going to be pretty interesting to see how they come down on that.
Yeah. And I wrote a whole analysis piece about this back in February when the Rahimi case was first decided, that looks at sort of how is the Supreme Court going to come out on this? But, it's really is something the Supreme Court had to take up, honestly, sooner than later, because as you wrote in an analysis piece too, this was beginning to cause a lot of circuit splits. These, or not a lot of circuit splits, but it caused a circuit split, the prohibited persons categories, not the domestic violence restraining order one in particular, but all of the different ones that exist in federal law. You're starting to get circuits ruling different ways on them. And then at the same time, you're getting a lot of district courts going completely opposite directions on this same question as well. And so this is kind of something they had to, at some point, address because it's becoming a major issue. Now, the Supreme Court has talked a little bit about these prohibitions in federal law, right?
Yeah, in dicta and Heller and reiterated in McDonald and once again reiterated in Bruin, they've sort of said it's, they've sort of just like said it's self-evident almost, like, oh, nothing we're saying here should cast doubt on felons not being able to own guns. So that's sort of been
I mean, they're not saying it's evident that like the law is constitutional. They're just, I don't know. It's kind of more of a these rulings don't explicitly implicate the felon in possession bans or the mental people banned for mental illness, right?
I guess it's fair. Lower courts have interpreted it as them saying it's self-evidently correct, which they have that's gotten them into some trouble in some rulings, as we've covered previously. So I guess that is a fair distinction. They haven't said specifically it's constitutional. They just said nothing we've said thus far has cast them into doubt.
They're kind of implying they're constitutional, or at the very least that they're not affected by Heller and McDonald. Bruin, you saw it repeated in the concurrence from Roberts, which also kind of gets to like, how is the Supreme Court going to come out on this? Because if you recall, the concurrence in Roberts, the Kavanaugh wrote the concurrence. Roberts joined the concurrence, which gives you 2. And then if you add that to the 3 liberals who are almost certainly going to vote to uphold this, maybe they won't, who knows, we'll see, but I would imagine they probably will. That gives you 5, which is all you need. Now, obviously, the Bruin concurrence doesn't deal with this question of, the restraining order, whether that's a high enough legal standard to strip someone of their constitutionally guaranteed rights. That's probably the strongest argument that Rahimi has, I would imagine, because I don't think that the court is going to say, there were that there isn't a historical tradition of trying to keep dangerous people from owning firearms. But they might say that a restraining order process is not a strong enough process in terms of the legal protections it offers. To justify taking away somebody's constitutionally guaranteed rights. It's hard to say, though, exactly where they're going to come out.
Especially, especially there's another wrinkle, the circuit split you referred to earlier, like the Range decision in the Third Circuit, and there's which struck down a nonviolent felony in possession prohibition or conviction. And then the Eighth Circuit came on the opposite side of that decision. The federal government has not yet applied for cert in those cases, but if it does, which I assume it will because it's dealing with a federal statute, could the Supreme Court take that as well and sort of deal with these issues together, sort of like you've seen with the affirmative action cases where they're relevantly similar cases, so they decided them together. And I think adding a more sympathetic plaintiff in Range, for example, it's a nonviolent felon who, his food stamp fraud is not exactly something that most people are concerned with when it comes to gun ownership.
Yeah, a couple $1,000s of food stamp fraud is not the same level as what Rahimi's accused of doing.
You could see maybe perhaps that swaying how this comes down, where they just deal with the broader question of who is covered by the Second Amendment instead of just narrowly focusing on the Rahimi case in particular.
Yeah. I mean, you could. I don't know. Maybe I wonder if they would have just relisted Rahimi if they were going to do that. It's hard to say. It's a good point. Sure. Maybe we'll have to have like a Supreme Court expert on to try and, because the Supreme Court is notoriously hard to, suss out exactly what
reading the tea leaves is tough.
You got to really follow the Supreme Court to understand that stuff. But either way, it'll be interesting to see where they come out and whether they try to take a broader approach to answering some of these questions or if they just go piecemeal. To me, I kind of wonder if they won't do the piecemeal thing because, like, they handed down the big ruling in Bruin, and now they're going to have to answer the conflicts that come out from that. But I doubt they're going to want to completely redo the test or anything along those lines. The same exact court, right? That just handed it down last year. So I don't think they're going to come back and be like, never mind, we're going to change this test completely again. They'll probably just give you their take on how to do the test properly in this particular circumstance, which will give some guidance. But I mean, that's really how they do it with most other cases, right? It's not, you're not necessarily getting a new First Amendment standard, test every year, right? But even though you'll get First Amendment cases all the time, Second Amendment has just not gotten a lot of attention from the court up to this point. Probably in large part because for most, until like 1934, there weren't federal gun laws. And the incorporation doctrine, where the Bill of Rights and applies to state laws as well, that didn't come until later either. So there wasn't that much opportunity for the court to talk about the Second Amendment before the federal government started passing gun laws. So, that's part of the reason why there's not as much history there. But the practical reality is that there isn't a lot of history, and they really just need to take more cases to build up a better understanding for the lower courts of exactly how this test is supposed to play out.
Right.
And I guess that's exactly what we're going to see. So we will certainly stay on top of that. And so make sure you keep up the reload, subscribe to our newsletter and buy a membership. But speaking of memberships, we have a member segment right now. One of my favorite segments. We're going to go talk to an actual reload member. All right, it's time for one of my favorite segments, our member segment. We have reload member Michael with us this time. How are you doing today, Michael?
Doing great. I want to say definitely thanks for having me. Really looking forward to it.
Yeah, absolutely. We always appreciate whenever members want to come on and do one of these segments. It's good to get to know the community that really makes the reload possible. And I'm always interested in, people's individual personal stories. And I think it adds a lot to the show. It gives people, some FaceTime with actual gun owners in a lot of circumstances. Not everybody who's a member is a gun owner, of course. You can be a reload member and not be a gun owner, but many people who are interested in what we write about naturally are gun owners. And I believe you are a gun owner, right?
Correct. Yes, I am. Since 1997. Yep.
Nice. What's your latest gun?
Latest is a SIG P365 X macro with the Romeo Zero. Already thinking about potentially just looking at it and reading, going for the Holosun, but it remains to be seen. Got to fire it first.
We're gun twins then, though. That's my latest gun as well. As members probably already know from reading the Sunday newsletter, but the Zero Elites are. Sounds like we have the exact same one because I also bought the factory optic installed version. It has a little shield on it too, which is giving me some trouble with holsters. It does fit the Enigma. Okay. The Filster Enigma holster works perfectly with it, which I cannot say about the Alien Gear or the CYA holsters. Some of these other ones that I've tried, the shield creates clearance issues. Even if you've got the optic cut, they'll say they're optic cut, but not necessarily.
No, the little thermal won't help sometimes.
Yeah, very true. But and I also have considered if I was going to do it over again, I might go to the Holosun instead of buying the optic ready, like the installed one, because it does seem like the 507K or whatever. Yeah, seems like a pretty sweet option and a bit of an upgrade from the SIG versions. But honestly, it works well enough. My main issue was that the battery died really fast. But I haven't had that issue again. And if it doesn't keep dying, every 2 months, then it might not be a big deal. Yeah, I guess I'll have to see. What's your favorite gun?
I'd probably say my VP9. Love that. And then that, and actually it's one I have since sold, but was my Glock 23C. That was actually the first handgun I ever purchased. Once again, back in 97. And just always, I sold it many years ago, but always had a soft spot. Now, the interesting thing, too, that was obviously during the assault weapons ban. And what a lot of people don't realize is that you could still get high-capacity magazines then. They just had to be manufactured before the start date. So I got mine with 13 rounds because it was 40, the 23, and then got some more. Ended up selling it to a really good friend of mine years later. But that, and like I said, probably the VP9 are probably my favorite firearms I've owned.
VP9. So do you watch Active Self-Protection as well?
Yes, I do. Korea. I think he switched to P30 though. I think,
I think he did. But he was always a big VP9 guy for a long time.
I think anybody that does self-defense, John does one heck of a job with just really breaking down and dissecting what it means to use something for defensive use and the good, the bad, and just what the heck are you thinking? Yeah,
absolutely. One of my favorite. And I guess I should plug the Active Self-Protection podcast since I do the news update on that every week.
Okay.
But good a time as any to tell people to check that out. Or if they're interested in, self-defense stories, that's the best podcast out there for it.
Absolutely.
I think. But so tell me a little bit about how you got into guns, your relationship with guns over the years. Give us a little bit of insight about yourself.
Certainly. So when I grew up, I really both my grandfathers hunted, but by the time the grandkids came along, I'm the youngest. The grandmothers had pretty much said they need to be put up, and so they were. So they were, for lack of a better word, they were in gun cabinets. That's it. Always admired from afar. Probably the closest I had ever done was shoot one of my grandfather's air pistols. That was about it. When I like to say, it's interesting, kind of like what they call, I apologize, but gun people 2.0, if you will, and I apologize.
Gun culture 2.0.
Thank you. I apologize to Professor Yomain. I butchered that, but I kind of feel like I was that a little bit early. Primarily, I wasn't really interested in hunting. I did like handguns. It wasn't necessarily from movies or anything. It was protection. I worked actually at a retail shop and had to do night drops, and we weren't in the dangerous part of town, but it was not exactly the best lighting and anything else. And I just wanted something to feel protected. So that's when I once again turned 21 and got my first Glock, if you will, and outfitted it and did everything else. And just it kind of became a little bit of a, I don't want to say a love affair, but a little bit of a passion. Got many throughout the years. I remember Colt Defender, the old was it Rossi 971, 357 Magnum, several other, primarily handguns generally. Didn't really do much with rifles or anything. And then kind of one of the things I really wanted to focus on that you and I think, when we corresponded with, is it really is for me. I have to admit, depression, mental illness, and actually addiction plays a part of my story. Never was suicidal. Never thought about, using my firearms to hurt somebody or murder somebody. But I think, especially hearing today's, a lot of things that's going on today, mass shootings, gun control, gun safety, common sense, whatever you want to call it. Mental illness plays a large part in it. And I consider myself very grateful and very blessed where the first time I ever had a serious issue with mental illness and depression, didn't really know where to turn. I was lucky I had a friend that I was able at that time to give my firearms to. Yeah. And I just asked him, would you mind holding it for me until I feel better? And he did. And I sought the help I needed and got the help. At the time, I was still honestly dealing with addiction and terms of alcoholism, which I don't mind telling you is a barrier in and of itself. That really hadn't taken a grip yet. It was primarily depression. And I didn't have my firearms for about, I don't know, maybe 1.5, 2 years, I think. And, for me, I think for gun owners, that's an issue we have, is asking for help. And you hear it in today's politics by a lot of people, red flag laws, which, once again, in theory, seem they'd work. The problem is most people, I don't want someone coming in and just telling me, yes, you have to give these up now because someone said something and they don't understand the case. I don't believe most doctors really are. Most doctors and professionals these days really want to understand the gun culture and understand why it is important for people, even if they are struggling, to still be able to defend themselves and defend their families. It's a big part of it.
You've certainly seen this discussion come up a lot in recent years inside the gun owning community, right? Because there isn't necessarily that inherent understanding of the culture of gun ownership from a lot of medical professionals or suicide prevention groups that are, general suicide prevention groups. And it can create the sort of issues that you're discussing here, right? But you have seen these sort of more grassroots efforts from the gun owning community and to some extent from the gun industry itself in trying to come up with solutions that are tailored for gun owners who are struggling with mental health issues, with suicidal ideation, with addiction, and one of the options out there now that's more developed in recent years, something that perhaps was not available to you at the time, although it sounds like basically what was already happening in the community, as you're describing here, it's kind of developed into this grassroots movement of, hold my gun.
Yes.
Right. Because what you're talking about sounds very similar to what that effort is, which is, somebody's going through a mental health struggle. In your case, you had someone that you could turn to hold on to your firearms while you were dealing with that. And that's kind of the exact idea of this program that's come up in recent years.
And I believe that's done through FFLs. So they have insurance, they have everything else. It's not just like you're handing it to a gun shop and then they just basically they can do what they want with it. Yeah.
Right. It's a little bit more of a formal program for that sort of centered around that solution that you took advantage of, thankfully. Right. But can you walk us through what that was like for you to make that decision? Obviously for gun owners, I mean, you're describing yourself here as like this classic gun culture 2.0 type person who wants a firearm for self-defense, for protection. I'm sure a lot of people tie gun ownership to part of their, especially political identity, right? It's certainly something that a lot of people put a lot of value in as part of their core system of beliefs, of like being an American, of being self-sufficient, of being able to protect yourself and your loved ones. So what was it like to realize that you needed to give that up for at least a period of time to really ensure your own safety in that way, right?
For me, it was a little twofold, and I did want to. I'll add something real quick. I do think another thing is honestly the masculinity part. I mean, at the end of the day, I think it's hard for men. We're the largest number of suicides out there. We typically are the largest number of guns. It is difficult. While I never contemplated suicide, most people that do, even with a firearm, I know a lot of the gun control and common sense say, "Oh, it's people get a gun, they do it really quickly." People think about suicide long and hard. Honestly, the only reason I don't think I ever hit that wall for there is because I had a relative die in their early 20s. And for me, I saw the impact it had on my family. And I think that's why I never went there. But going back to your point, for me, it was difficult because I did feel I'm giving up my ability to defend myself with what I've trained with and whatnot. But I think most people really that think about it, when I saw my family, they were concerned about me. I wasn't married at the time, but I had other family members that just said, "Look, we're worried about you." My brother just said, "If you ever need something, if you would need me to hold something, let me know. I don't think you're there yet, but we're worried about you." And for me, that's what sunk in. I kind of had to let that really overtake the other concerns with, hey, I'm going to be defenseless. I lived in an apartment at the time. It was relatively safe. And at the end of the day, I just kind of looked at it and said, it's either one or the other. Either, I trust this person. I know they're going to give it back when I ask them to. I trust their opinion. I think the biggest thing is it was safety. It was a safe place. It was something that I knew that even though I wasn't 100% in control of my emotions and myself and my depression at the time, I was in control and could say, look, I would like my firearms back. And it was fine. We had a predefined, and I set the terms. 6 months. We'll see how I feel. Didn't feel great in 6 months. We went another. It kind of went on like that. I think it's much easier to give the gun owner, unless they're in severe crisis, the option to say, I can make the decision. And I think most rational people would be able to say, look, I can go a little bit longer without it, or I'm still not through what I'm dealing with. I'm still uncovering things.
And it sounds like a key component of that was this level of trust that you had with the other person who was willing to hold your gun for you. And I think that's where a lot of maybe well-intentioned things like you brought up red flag laws. It seems those get used, obviously, politically. The arguments tend to be around mass shootings, but in practice, they mainly are used in suicidal situations. And, they're well-intentioned, surely, but they do have drawbacks of the fact that, that there's not that level of trust involved when you have the cops come or court order you to give up your guns. It's a different situation. Maybe it's necessary in some circumstances, but it's not it really shouldn't be your main approach to trying to help somebody who's a gun owner and who's having suicidal ideation.
Yeah.
Like you would presumably, and this also goes back to even when it's not something like a red flag law, or there's no distinct direct action being taken to remove somebody's guns from them if they talk about their mental health struggles. But there can be situations like where doctors will ask if you own a gun, or then it sort of creates this atmosphere, I think, for a lot of therapists or doctors where there's sort of an implication to the patient that if I tell you I am a gun owner and I'm having a mental health, crisis, that will automatically mean I don't have any recourse to keeping my firearms, and so maybe I won't tell you at all.
Correct. And speaking to that, I go to see a therapist now, and they know I own firearms. I'm very, as you can tell, I'm pretty blunt. I really don't hold much back. And I told them from the get go, look, here you go. I'm a firearm owner. And we talked, and part of that problem was when I was going through issues with alcohol, and my wife had another experience. She asked me, she said, I would just feel better if you have this with somebody. And I did. So so it repeated itself. Thankfully, everything's fine. And I've been sober since 2014. My apologies. So
that's awesome. But, that's fantastic.
Thank you. But, a lot of it really comes down to, I think it goes back to the trust. I always like to say this. I didn't get better until I found a doctor that I could trust and that I could listen to, and that I was willing to be honest with. And I think that goes a long way, not only erasing the stigma with mental and addiction issues, but also too being able to just say, look, I saw him a couple weeks ago and he was like, are you okay? Everything's fine, but hey, great time to have a short visit when things are going great. But, it really opens it up to just, you can be honest and say, I'm going through a tough time. And we've had the conversation where he said, look, if I ever feel you're in a little bit of a danger or you're getting on the edge, because I'm going to tell you and I'm going to call your wife. And I gave him permission, obviously, but we're going to take a look at what we need to do just to make sure everyone's safe.
Mm-hmm.
That's the end of the day. That's all. I think that's all anyone can ask. It's being safe with myself, being safe with my family, my friends, etc. Having that trust there, but also having the realization that just because I choose to give something up doesn't mean anything's being taken away. Right. And I think that's a big, big difference. I don't like anything when it's taken away from me. But if I choose to give it up for a reason, I can rationalize it all day, all night.
Yeah. And I think that that's such a key point in this discussion, because if people want to help others who are struggling, because, thankfully sounds like you're in a healthy place now. Mm-hmm. You're somebody who's taken those proactive steps to get help. A lot of people don't do that. Right. Yeah. And certainly it's not an easy thing to do. Right. I mean, for anyone, but it makes it even harder if there's this artificial barrier in the way that you might not be able to trust when you walk into a therapist's office, that they're not going to do something you really don't want them to do in terms of taking your firearms away from you at the moment. And so what was it that, when you were looking for a therapist, when you were looking to talk to somebody professionally, about this, that, how did they gain your trust? What was it about them that you were able to open up on these fronts?
There's two things. The first one, and I hate to sound like this, they didn't take insurance. I'm very grateful where I can afford to pay for the hourly rate. Every therapist or every psychiatrist, anybody I've ever seen before, has always been, you're in the office, you're out of the office. You feel like they're listening for a second and then you're gone. They give you medicine and then on your way, come back and tell us how you feel. My first appointment with this doctor was almost 2 hours. My wife was in there with me for about probably the first 45 minutes, just really discussing not only what I saw, but what she saw. And I had that level of trust with my wife. I have that level of, just really, I want you to tell him what you see if I have issues and when I'm going down, if I'm on a slope or whatever have you. And he just sat there and listened, didn't give anything, and just said, look, it's, let's give it a shot for a few ones, and we'll kind of see from there. I want to see how you are on this medication that you're currently on. I want to see how it works for you. And it took me to being at a bottom, if you will. And I dragged my my butt to his office at probably one of my lowest points in my life. And he saw the difference between me being on medication that worked and medication that didn't. And the first thing was really just, instead of just shoving me right out of his office and saying, here's your prescription, here you go, this will fix everything. He really took the time to half an hour, ask me questions, what was going on the days prior. And for me, it was the listening, the understanding, and not talking about anything extraneous. Just, I'm talking to you now. Don't tell me what you don't want to, but just please answer me honestly. You had, luckily, in my opinion, the courage to come in here at your lowest, and you could have blown the appointment off, and I didn't. I'm very grateful for that.
So he's very intentional, it sounds like.
Oh, extremely. And I
gave
think
you
that's
space.
just it.
To explain things. That's
and he took the time. I mean, for the shortened version, he really took the time to listen to what I was saying and really understand it. I
mean, he didn't try to stigmatize you for owning guns. He didn't try to tell you nothing like that.
Nope. That he knew I was a gun owner from the very beginning.
Yeah.
He asked. Once again, I'm obviously very honest about it, and that subject didn't come up until about 3 sessions in. And he asked me just, where are they? And I told him at the time they were with a relative, and they're just for safekeeping, because my wife asked me to. Yeah. And just kind of went in, I wasn't suicidal, wasn't threatening anybody, wasn't thinking about any homicidal.
Right.
Just made her feel better. But 3 sessions in, it was still focused on me, and that's it, and what I was doing. Well, 3 sessions, that's not bad.
Yeah. Well, I think that's something that a lot of therapists can learn from when they, especially they're working with a gun owner. You brought up David Yamani earlier, Professor Yamani, and one of his sayings is that guns are normal and normal people own guns.
Yes.
Right. And so, that's something I think that needs to come into the discussion when it comes to mental health treatment. Like, the gun ownership in America is an extremely normal thing. 46% of adults report having a gun in the home. 33 to 35, somewhere in there, report owning a gun personally. So that's hundreds of millions of people. It's not an abnormal thing. It shouldn't be treated that way. It shouldn't be stigmatized when somebody comes into a doctor's office. And I'm sure hopefully it's not in most of them, but that's an understanding that therapists need to have if they want to try and reach this community of people who own guns. Because otherwise it can lead to people not wanting to seek out that sort of care and treatment. But I'm very glad that you did, and that you've done the work on this front. Because even with all that, even finding a good therapist, it sounds like you had a good community around you to the points. You had people who really cared about you, and you had stayed connected with. That's super important too. It's not just about the people, the trained professionals. It's also about the people around you.
Don't get me wrong. There was definitely some tough love in there that made me seek out some help. But no, to your point, yes, it definitely was that. And just, if you don't mind me adding a point, I think that one of the biggest struggles right now is social media, Twitter, which has great stuff on it too. But you have really, I feel like everyone can isolate themselves, whether you are right wing ideology, left wing, and the center. And I think for people with mental health issues, it really gets distilled down to, holy crap, they both, either they want me to have anything I want, or they're wanting to come in and jack boots and take it.
Yeah.
Who do I listen to? And at the end of the day, that's one of the things I love about this podcast and your coverage is I really feel it's very even keeled. And I may not agree with everything all the time, depending on my political leanings, but at the end of the day, the joke I always like to say is the adults are speaking.
And that's what we try to go for. Yeah. And I think that people do appreciate that level of seriousness, right, to the conversation. I mean, this is something that affects so many people, and it deserves to be taken seriously. And people who report on it should be informed about what they're reporting on, right? There's just some basic level stuff that we believe in at the Reload that, is lost, I think, in a lot of other forums, regardless of what side of the aisle you're looking at, or, if you're looking at big, giant publications, if you're looking at, little publications, there's a lot of places that just don't adhere to that level of sober, serious approach with informed, independent, staff. And
It's a complex issue, and it can't be distilled easily. And I think, I mean, I know that's the media's job, is to distill everything into soundbite, get ad dollars. But it's just like there's so much going on behind it.
Right. Yeah, and it's responsibility, I think, as a reporter to your audience to do your best to inform them rather than inflame them. That's another David Yamani saying. He's got a lot of good ones. Light over heat, right? And so I think that's what we try to do, and I'm it's working so far. We're able to, thanks to members like yourself, we are able to keep the lights on and keep reporting, which is all I can really ask for, right?
And hey, almost had 2 memberships there, so great.
Yes, and I also do the customer service a lot of the time.
Phenomenal customer service, by the way. Yes, save me some money.
All right. Well, we really appreciate you joining the show and giving us some really good insight into your story. I mean, it's an important story. I always love when we have a member segment that can also just converge on things that we focus on reporting about. And talking to like real everyday gun owners is such an important thing that just doesn't happen that often in media. So I'm always glad whenever we're able to do it.
I appreciate being on, and once again, I mean, it's definitely been an honor to be on with you guys and talk about it for sure.
Absolutely. Well, anyone listening wants to join the podcast for a member segment, you should head on over to thereload.com and buy a membership today. You'll get not only the opportunity to appear on the show, you'll get early access to it on Sundays. Everyone else gets it on Monday. And you'll also get exclusive access to hundreds of pieces of analysis and reporting that you will not find anywhere else. And it is also, of course, the way that we keep the lights on here at The Reload. So head on over to thereload.com and check that out today. See if you like what you see, and go ahead and buy a membership. But that's it for this week. We will see you guys again next week.